Let's start with marriage history. Ancient times. There's evidence that monogamy was established 20,000 years ago, at least 20,000 years ago. But of course, as we know, there's been polygyny, rare, one man, several women. We've all heard of stories and fairy tales about harems, and it's rare but practiced. Common in the Hebrew Bible, where wives were property. In Islam, up to 4 wives was and is still legal, quote unquote, from that religion's perspective. Polyandry with 1 woman and several men, very, very rare. There's evidence that in Greece and Rome, in ancient times, there were same-sex relationships, close public same-sex relationships. When you jump ahead to medieval times, what you see is monogamy, with authority oscillating between church and state. An arranged marriage in Europe eventually yielding to mutual consent over time. And as we move into modern times, it's mostly monogamy with mutual consent, except in various primitive societies. Polygyny is rare in Islam, although still permitted, and very, very rare elsewhere. So let's jump to same-sex marriage and the world, just some statistics. 13 countries, it's legal. In the US, we now have 12 states, and I had to keep changing this slide. I started out at 10 and 11. And you can see, I think it's accurate, unless another state came through this yesterday. And then there's some bills allowing legal recognition of same-sex marriage, proposed, pending, or have passed at least 1 legislative house in that assortment of countries that you see at the bottom of the slide. In terms of religion, and one of the things that's very frustrating to me as someone who's very active in PFLAG and participates in PFLAG support meetings. Most PFLAG chapters, and there are over 350 chapters around the country, will have a support meeting every month, same place, same time, for families that are having difficulty coping with the fact that a child has come out as LGBT. And one of the things that we learn is that the more fundamentalist, the more literalist a religion is, the more difficult it is for that family to be accepting, the more difficult it is for the son or daughter to, some cases, to survive the coming out process. So the religions against same-sex marriage, you can see them listed there: Catholicism, Christian Orthodoxy, Mormonism, Baptists, Evangelicals, and Fundamentalists, Islam, Orthodox, Judaism, and some subsets of the Hindu and Buddhist religions. But the religion that support same-sex marriage, you have an assortment of relatively small Christian groups.
Episcopal could be on the list.
Episcopal
Yeah.
should be on the list. I'm sorry, I should have included that. You're quite right. I'm proud to say, as a Jew, that the conservatives came on board in 2006. And in fact, I'm personal friends with the local LA rabbi who made that happen, Rabbi Elliot Dorff, who's the rector of the AJU. The Reform movement has been on board for many years now, and as has the Reconstructionists, which is a small group. And then the liberal Buddhists and Hindus are on board. Just a quick summary of what DOMA is. The Defense of Marriage Act restricts federal marriage benefits and required interstate marriage recognition to only opposite-sex marriages. Signed into law by President Clinton, unfortunately, in 1996, and it codifies the non-recognition of same-sex marriage for all federal purposes, such as Social Security benefits, such as filing taxes. A very egregiously unfair issue is with respect to immigration, that a person who is married outside the United States, an American who's married to a non-American, cannot bring their spouse into the United States legally. An egregious violation of equal protection, in my opinion. In terms of what the status of Section 3 of DOMA is, which does deny this fairness, is it's been found unconstitutional, in 8 federal courts. And coming up to this discussion later, because we have experts here far more knowledgeable than I, the U.S. Supreme Court has heard an appeal in one of these cases, United States versus Windsor, and I know many of us have been watching that very, very closely, so we're going to be talking about that when I'm done. One of the things that I'm proud, one of the reasons, just a little background, my family lived in Florida for 21 years before we moved here 11 years ago. And one of the reasons, I mean among several reasons, was that Florida has no laws that protect LGBT people, while we knew that California did. And so just wanted to flash up the status for LGBT people in our state. We should be proud of this, that we are citizens of a state that treats LGBT people fairly. Hopefully, we will very shortly, within 30 days, perhaps every family will be treated fairly here if the Supreme Court rules the right way. Next slide, please. This is just a quick summary of Prop 8. It was ruled, the California Supreme Court ruled same-sex marriage legal in June of 2008, and 18,000 couples married happily, and they're still married, also happily. The limit on marriage constitutional amendment was approved, as most of us know, by a small majority in November of that year, and many of us in this room fought that tooth and nail. The California Supreme Court upheld Prop 8 on June 29th, 2009. There were several lawsuits filed, and I'm good friends with some of the complainants in the lawsuit. And on August 12th of 2010, Judge Walker of the Ninth Circuit ruled it unconstitutional, and as most of us know, we had oral arguments in March. So it's exciting. This is that we really are on the cusp. If you remember my words in the video, we're on the cusp of hopefully a positive change. And now I'd like to, all of us should enjoy this video. If you have not seen it, I expect to be surprised. This is an official of the New Zealand legislature talking about same-sex marriage. So it's my pleasure now to introduce our first guest speaker today, Melissa Goodman, Senior Staff Attorney with the American Civil Liberties Union, Southern California branch. And you can read her credits: conducts legal and policy advocacy concerning LGBT rights. She is a true expert, and she served as co-counsel in Windsor versus the United States, the challenge to DOMA. So we're getting it from, dare I say, the horse's mouth. We're very lucky.
Thank you very much, Steve. Hi, everyone. Good morning. So I'm going to talk a little bit about these marriage cases in the Supreme Court. Just so I know, I like to. Do we have any lawyers in the room? Okay, we have one. I like to. It's not a presentation built for lawyers, but if you have lawyerly questions, you can ask them at the end. You can actually go to the next slide. So, but before I do that, I just want to tell you a little bit about the ACLU's LGBT work. People are actually kind of shocked to know that the ACLU has been doing LGBT work since 1936. When Lillian Hellman, who was a playwright, I think this was in Boston, her play, The Children's Hour, was banned from Boston theaters, and that was sort of the ACLU's first LGBT rights case. But right now what we do, the areas we focus on are kind of, as it says, all of them. Basic rights, which are, in California, you saw that great thing that Steve put up. We have achieved in California, with the exception of relationship recognition, basic rights. And we're very lucky to do that. In many states, there's still no, and in federal law, there's no protection from being fired because of your sexual orientation. Sometimes you can't adopt children. Sometimes you can be discriminated against in stores or restaurants. Those are basic rights. relationship recognition. We do a lot of parenting rights work. We do a lot of youth in schools work. And we do a lot of transgender rights work, which is sort of more of the cutting edge stuff now. I think if you read the paper, listen to the radio, you know that not only in the last 10 years has there been enormous progress on this, but I think literally in the last month we've sort of grown the states where marriage is permitted almost by like a third. It's really, really enormous and really amazing. And you know, part of this strategy all along, you know, groups like the ACLU's LGBT Project and affiliates like mine and other LGBT groups, you know, have really, you know, thought this through a long time ago and have had a strategy for how to make this happen. And what you're seeing right now is the sort of culmination of that strategy. So some cases in the courts, some legislation, some states where we said let's go for it legislatively. For example, until very recently, I worked in New York. I worked at our New York office. And was very lucky to be involved in that movement, legislative movement for marriage equality there. And you're seeing this in public opinion, doing real public education. And what the real public education has been about is what Steve already told you, which is talking to people about how love is love, essentially. That this is all about just letting people who love each other have the kind of committed relationship that they want to have. So lots of progress, lots of progress. The only thing I'll say about progress, you'll see it more specifically, is that it's really good for the Supreme Court to see. And it's really, really important. So I think what's happened in the last couple of months kind of went beyond anyone's wildest expectations of the progress we would see while the Supreme Court justices were considering these very issues. So that's very exciting. All right, so the lawsuits. I'm sure this crowd already knows all this, but I'm going to tell you anyway. There are two cases, and I'm going to talk a little bit more today, but I'll answer lots of questions about Windsor, only because it's been my feeling that, you know, all these great California people know a lot about the Prop 8 case, and some people don't know as much about Edie's case. But Windsor, so there are two very different cases, and therefore two very different issues before the Supreme Court. Windsor is Edie Windsor, and the ACLU's challenge to the Defense of Marriage Act, which you've already heard about, to a part of the Defense of Marriage Act that says the federal government, even if you're married, even if you live in a state that lets you get married to your partner, the federal government will not treat you as married. They will say you are single because we only recognize marriages between opposite sex couples. That's the part of DOMA that we're challenging, and that's before the Supreme Court. In Perry is obviously the challenge to Proposition 8. All right, so I like videos too, so I might not say very much now and just have you watch a video in a second, but two things I want to say about Edie and Thea's story. First, they're remarkable. They were together for 44 years before Thea passed away. And actually, I'll wait until after the video to tell you about it, but this all came about because of DOMA when they got married very, very late in Thea's life, and when she passed away, Edie had to pay a huge, huge estate tax, nearly $400,000. And it's a tax that she would not have had to pay if she was married to a man. And that is sort of the context of that case, and whether, that's what the Supreme Court is deciding, whether the law that imposes that kind of discrimination on Edie and Thea, or Edie after Thea died, is constitutional. But I'm going to just show you a little thing about Edie and Thea and their life. You might have noticed in one of the pictures with Thea, I think they were in a hospital room, that Edie had a circle pin that she was wearing on her lapel. And that pin was actually something that Thea gave to her in 1969. Edie and Thea actually got engaged in 1969. In a time when who could even imagine that it was conceivable in their lifetimes that they could actually get married. But during that time, they were both terrified to wear rings, because obviously that would, raise some questions. And they were not out at work. And in fact, Edie worked for IBM, and she had a security clearance. And that was during the time when you could have your security clearance revoked if the FBI learned that you were gay. So it was a big secret. But they wore those pins, all their lives, and he still wears it every single day. So anyway, that is Edie and Thea. And I show you that because the rest of what I'm going to say is going to be a lot of, legalese and things about the law. But the thing that's actually important to remember about all these cases and all these twists and turns they could take legally is that, what I hope the Supreme Court focuses on, and I guess what we're all hoping, is that they'll focus on what it's really about, which is the love, that Edie and Thea share, that all of the couples in the Prop 8 cases share, and not get so swept away in all these sort of technical mumbo-jumbo stuff, which is what I specialize in. But, I just wanted you to see that before this. But I will get to the legal argument things. And for this, if I use any technical terms that you have questions about, you can ask me as I go. So there's a couple different legal arguments that are before the Supreme Court, as I fall over. The key thing that you probably know most about is an equal protection argument. The Equal Protection Clause says that all, people need to be treated equally. And the question is whether government discrimination based on sexual orientation violates the equal protection guarantee. One issue that is embedded sort of underneath that big question that is a really big deal but not getting as much attention is, because it's kind of technical, is in answering that question, what level of scrutiny should the Supreme Court apply? We have made an argument that any law that discriminates based on sexual orientation should get the highest level of judicial scrutiny, the kind of scrutiny that gender gets, or race gets, or somewhere in the middle. That basically is a kind of standard of review where the court looks at something and says, I'm gonna start from the premise that this is suspect, that this is probably not okay, and you government have to really show me, like in serious terms, why it's okay. That's heightened scrutiny. Well, we've also argued that DOMA and Prop 8 as well fail under a much easier test, which is rational basis, which is there some rational reason for having this law? And we think it fails both. So the Supreme Court could reach this question of what level of scrutiny. And the reason I say that's a very important question sort of underlying all of this is because however they rule on marriage, if they were to come out and say laws that distinguish between people based on sexual orientation get this higher level of scrutiny, it means that any law that does that now is much easier to challenge. So it could have a much more sweeping effect in terms of equality. So look out for that. We'll see what happens. And we tried to make our best argument that should be the case. The other issue, just one more thing on that slide. The other issue, and this is raised much more in the Prop 8 case, is whether same-sex couples have a fundamental right to marry. The real difference between the DOMA case and the Prop 8 case is that the Prop 8 case is about whether your state, any state, possibly any state, let's at least say California for right now, whether California has to allow same-sex couples to get married, and whether denying them that opportunity is either a violation of their equal protection rights or their fundamental right to marry. It's about whether states have to let people get married. DOMA is actually not at all about whether people can get married or not, which is why it's, we always talk about them as marriage cases. Edie and Thea were already married. Lots of people around the country are already married. It's a question of whether the federal government can refuse to recognize that marriage, refuse to treat people as married. And those are very different questions and can lead to very different results, potentially. The other side's arguments, I know I'm spending too much time on this slide. The other side's arguments basically boil down to two things. For both DOMA and Prop 8, that you're allowed to either limit who's allowed to marry in the states, or the federal government is allowed to refuse to recognize relationships for two reasons. Really because marriage is all about encouraging responsible procreation amongst straight people, basically. It's to make sure that straight people have children within a stable, committed family relationship that is marriage. And that if you allow other people into that, I don't know, it's very hard for me to articulate because it's a very irrational argument, but basically if you allow other people into that, who by the way can have children, for some reason you are taking away from the stability of heterosexual marriage. That's basically like the core argument. Uniformity is another one, but I won't get into that yet. Finally, next slide. Thank you. So there's a lot of text on these. I'm only going to say the sort of bold. I want to give you sort of the highlights. about the oral argument, and what you see in caps is sort of, in my lay terms, takeaway. I want to just say, before you take anything I say as gospel, nobody knows what's going to happen. No one can read the tea leaves on this one. I'm going to tell you my guesses, my best educated guesses, but that's all they are. Who knows? But this is sort of my takeaway. So the good things. I do really think, and this is the Prop 8 case, which was argued first. I really do think there was a lot of justices taking on this idea of whether having marriage restrictions, limiting marriage to opposite-sex couples, is rational at all. I think there was a lot of questions that suggest that. And frankly, the lawyer on the other side had no good, and I'm not saying this because I'm biased, I am biased, but he really, Mr. Cooper really had no good answers. I'll give an example, and then we'll move on. Justice Kagan asked this, so I told you the whole point of all this is responsible procreation, right? So Justice Kagan asked this, well, suppose the state said, Mr. Cooper, because we think that the focus of marriage really should be on procreation, we're not going to give marriage licenses anymore to any couple, where both people are over the age of 55. Would that be constitutional? So if you're tying it all to procreation. And he mumbles around a little bit, and he was like, no, you don't understand, men can procreate up until, whatever age, so that would be, would be rational. And there was a bunch of follow-up questions about, but wait, so if the woman in the marriage isn't fertile anymore, but the male is, aren't you encouraging him to go procreate outside the marriage? It went down a little rabbit hole, and I was like, wow, if that's the best you got, maybe we're all right. But there's more. But the next slide, please. Excuse me. But with all that and all the good questions about really sort of attacking the rationality, there was some bad. And when I say bad, there's two kinds of bad in the Prop 8. One is bad on the substantive issue about whether or not you think it is unconstitutional to allow same-sex couples to get married, but bad also in the I want to duck this case, I don't want to decide the issue, make it go away. So those are the kinds of bads. But the worst, I think, is that there were many justices through their questions where it seemed like they didn't, and this is true, I think, of a lot of people, both who oppose marriage or who don't know where they stand. They think of it as sort of a new thing. They don't think about it as marriage that you're just, including more people in. They think of it as something different, something weird, this thing. It's why you should never use the term gay marriage or something like that. It makes people think it's something other. So there was a lot of kind of offensive things said that suggested that, including things by Alito, saying it's so new, it's newer than the internet. We don't know if it works yet. It's well, marriage has been around for a really long time. We know a bit about marriage, and now you're just really including more people in it. I think the most disturbing thing to me personally was some of Scalia's questions, unsurprisingly, where he said a number of things, one of which is here, really suggesting that he just doesn't really believe that gay people can be good parents, which is a common refrain, unfortunately, amongst people who oppose fair marriage laws for same-sex couples. But he said some pretty offensive things. The reason it was doubly offensive was that, we have to remember we're talking about California. This is a restriction in California. And same-sex couples can adopt in California. There's no restriction. So he was really, kind of asking a question that I think was very disingenuous, because whether or not Prop 8 lives or dies has nothing to do with whether same-sex couples can actually adopt in California. So it was just trying to be sort of a scare tactic. Next slide, please. All right, but here's what really matters. As in most Supreme Court cases that we all care about, it is just true that Justice Kennedy is often the swing vote and the one that people try to curry favor with, right? So you do a lot of extra studying of what Justice Kennedy thinks. And here's my sort of take, and there's some quotes underneath it. I think that in the Prop 8 argument, Justice Kennedy seemed very moved by a particular argument, which was made by the parties, but also in a really excellent amicus brief by an organization called the Family Equality Council, that when you exclude same-sex couples from the institution of marriage, you're hurting a ton of children. Same-sex couples, at increasingly high rates, have children, and you are actually hurting these children, both kind of economically, because there's a lot of economic benefits to getting married, but also just sort of, psychologically and how they see their families. And he seemed very moved by that, but he also said a couple of things that suggested he might be in the camp that thinks this is like new marriage and not just regular old marriage. And also said some things that made it very clear that he really kind of wished he was not touching the question with like a 10-foot pole. Like, please, don't we have to do we really have to hear this case? He said a lot of things like that. And so, if I had to guess, Justice Kennedy does not want to decide the fun question in the Prop 8 case, which is, whether states have to allow same-sex couples to marry. I think he wants to dodge it entirely. That's my guess. But we'll talk about that in a sec. Next slide, please. All right, so then we have the DOMA argument, which happened the next day. And there's a little bit more good in the DOMA argument. The DOMA argument, it seems actually very clear, with a few exceptions, that a majority of the justices really don't like DOMA. They really think it is irrational and doesn't serve any legitimate purpose. And frankly, many expressed the view, and I say this, you can never tell by people's questions whether it's their actual view, so this is a guess. But many of them seemed to understand DOMA, in my view correctly, to be motivated not by some rational reason that the government wanted to do something smart and effective, but rather that they reacted in a knee-jerk way by animus, basically by not liking same-sex couples or gay people. And there was a lot of debate about that. But basically, a number of the justices really seemed to suggest that. Next slide, please. Okay, but then we have the bad, which is sort of overlapping with the bad in Prop 8, but more, actually I think Roberts was really the most active one and sort of actually ended the argument on a kind of yucky note, the technical term. He was just really pushing this refrain. So this matters sometimes because one of the ways you show that you should get that heightened level of scrutiny is to show, you don't actually even have to show this, but one thing you can show is that your group doesn't have meaningful political power. So that's one of the things that we debated. And Justice Roberts said a few things in a kind of sneering way about, hey, fine, maybe there was discrimination in the past, but look at all these achievements that are happening. Don't you think the history of discrimination is completely over? And that was sort of the note that the argument ended on. And I think what's difficult about that, and when you have these debates with others, it's not really political power, and it's not really, in the true sense of the word, and not, really being on top of the world when the wins that you get are actually just putting you on the same level as everyone else. Where the wins you're getting are just stop excluding me, stop discriminating against me. Those are very different types of wins than what we think of as I don't know, corporate power or things like that. Is that in my personal, non-ACLU way? But I think it's very different. Next slide, please. And then most importantly, or perhaps most troublingly, Justice Kennedy. So here's my take. Sorry, it's all in caps. I think Justice Kennedy thinks DOMA's bad. I really do. But I really think that Justice Kennedy is struggling with the main theory that we have put forward for why DOMA is unconstitutional, which is it violates equality principles. He wanted to find another way. Through his questions, it seems that way. It could be because, and this is my guess, because it's hard to accept our equality argument for why DOMA is unconstitutional, though there is a way, without then having to strike down Prop 8 too. And I think, though there is a distinction and there is a way, and I think Justice Kennedy was struggling with how do I do that? I really, I'm scared to go there on Prop 8. I'm scared to do something where all states now have to let people marry, but I really don't like DOMA. So what came out was a series of questions about, can I find DOMA unconstitutional on sort of federalism grounds? That is sort of this intrusion into states' rights. And people are a little worried about this line of questioning, frankly. Because the much better way to strike down DOMA is on equality grounds, and a very broad ruling on federalism grounds could have much more sweeping implications. It's the same kind of argument that was used to attack, the Affordable Care Act, and the things like that, and other things we might all care about. So that's what we're worried about now.
What are the 1,100 laws that Kennedy was referring?
Oh, what are they? Oh, there's so many of them. But
they
they're literally every federal law
Oh,
that talks about a benefit or an obligation that is put on a married person.
Okay.
So what DOMA did, and this is actually goes to why it's rational or irrational. When they passed DOMA, they just said marriage wherever you see it in the this is a shorthand for what it says. This is not if you read it, it's not what it says. But basically, wherever you see the word marriage in the federal code, that means marriage between a man and a woman. Doesn't mean anything else. And so they passed that law without actually doing an analysis of how many laws were affected, how many benefit programs, how many obligations. They just didn't even study it. But that's how many that it actually impacts. So finally, and I'm going over, so I'm going to skip my last couple slides after this one. The most important thing is what could happen. Here's my take. These are sort of the options. I'll go through what I think is going to happen, and if you want to know about the other ways, I will talk about them. In DOMA, I think we will get a decision on the substantive issue. I don't think they're going to kick it away without deciding the substantive issue. I might be wrong about that, but I think that we will get a decision. I think the big question, as I just said, is will we get a decision on federalism grounds or equality grounds? And will we get if we get an equality decision, will it be that rational basis, lower level of review, or will it be that higher bar standard of review? But I am actually still very hopeful that in about a month and a half, it'll be the last week of June when they issue this, I'm 100% sure, that we will have DOMA Section 3 at least, no more. But I could be wrong, and I'll be terribly disappointed, and then you'll have to invite me back, and we can all cry together. But that's what I'm hoping will happen. Prop 8, I have to say, it's much more complicated. They have a much more elaborate range, I think, of legitimate ways that they could decide this decision. I'm going to start with the first, and frankly, the route I think is most likely. I don't think they want to decide Prop 8. I don't think they want to go there yet. I think they're afraid. I think even though I think there are ways to decide the substantive question in the case without striking down marriage laws in all the rest of the country, I think they're still scared. So what I think they're going to do is that they're going to punt the case on a procedural issue, which is this thing called standing. Standing is whether you have a right to be in court to complain about something, sort of non-technical definition of standing. And you probably read all about this, which is a question they wanted briefing and argument about was whether the proponents of the ballot initiative, not whether they had the right to come into court to defend it the first time around in front of Judge Walker. Actually, nobody debates that they had the power to do that. There's this really complicated technical question of whether they then had the power and the right to appeal just Judge Walker's decision. And so I think it very likely, based on the tenor of the argument, that they're going to say that the proponents of Prop 8 did not have standing to appeal, which means they didn't have standing to be in the Supreme Court, and the Supreme Court doesn't have to decide anything. What that would mean practically, if they decided this, if they decided that way, is that Judge Walker's, so it's actually good news for California, if that happens, but not good news for anybody else. Judge Walker's ruling striking down Prop 8 would stand. It would be the law. There is a question about whether that decision would apply only in the territory that Judge Walker covers or the whole state. I personally think that what will happen, because how could you have this practically any other way, that if this was the result, it would effectively mean marriage was possible statewide, because I can't imagine the Attorney General's office or whoever wanting to have different marriage rules in different counties of California. But there might be, to be honest with you, maybe there's going to be a fight about that if this is the way it goes. But frankly, that's the way, if I had to put money on it, if I was a gambling person, I would go. But they could do other things. They could reach the merits, but reach it in a way where they only talk about Prop 8, and they say, only in California does California have to allow marriage. And that would be by adopting what Judge Reinhart in the Ninth Circuit Court of Appeals sort of decided. If you want to know more technically about that, I'll answer questions when I'm done. The other ways they could do it are what people are calling the 9-state solution. or the 50-state solution. The 9-state solution is a ruling that says any place where a state basically gives same-sex couples all the rights and benefits and obligations of marriage without calling it marriage, you can't keep them from marriage. Like, you're allowing it, you're just keeping them from the name, and that's stupid, basically. So that would be the 9-state win. The 50-state win is all states must allow same-sex couples to marry. I think that is the least likely. And of course, because I'm an optimist, I didn't even put the other side of that, which is they rule that way, but they rule the bad way, in my view, which is states do not have to allow same-sex couples to marry. So those are sort of the options, but I'm putting my money on standing. And I've gone way over, so I'm probably just going to stop here.
Hi, everybody. I'll tell you my story first. We talk about how when we talk about equality issues, you know, you want to have your elevator speech. My elevator speech is probably 20 minutes long, but your elevator speech about who you are and why you care about the issue. And I will tell you up front, before we do the presentation, I'll try not to go 20 minutes, until 2008, I did not believe in marriage equality. I've been married 36 years now. I was one of those people who thought that if it was the same gender couple, that it should be called something other than marriage, just because in my head marriage meant man-woman, not because I wanted to demean or degrade same-gender couples. And it was watching the first marriages that occurred after the California Supreme Court found against Prop 22, and marriages started for same-gender couples. And my husband turned to me and said, "Jane, why do you think it should be different? Don't you, having grown up in the segregated South, don't you believe that separate but equal is never equal?" And I had my aha moment where I forced myself to really look at what I thought about the issue. And that's when we have conversations with people, what we want to do is we want to tell our stories, how we came to care about the issue, and help them to work their way through those aha moments. Because there are lots of people out there who, you know, believe that Prop 8 was right for reasons that have nothing to do with hatred for the LGBT community or wanting to demean them. They just in their heads thought marriage is man and woman. So fortunately, I saw the light before Prop 8, and in fact campaigned against Prop 8, was out there handing out those cards the day of the election, and afterwards got pretty upset, happy that Obama was elected, really unhappy that Prop 8 passed, and I looked for a way to get involved, and I found Marriage Equality USA, which is all volunteer except for one staff member. We have one paid staff member now, just in the last year, and got involved in creating an LA chapter, and I encourage you, I'm sitting around a sign-up sheet if you're interested in finding out about things like, Steve showed you the video of his speech on the steps of LA City Hall right before the oral arguments. I'll let you know about events like that if you want to sign up for our email list. So, all right, we don't know yet what the Supreme Court's going to say. So where do we go from here? We've seen some recent successes. This is the slide from the Williams Institute, and the changes since 2009, the percent of same-gender couples that live in states where they can marry. And you can see this final column assumes that California and Illinois will both recognize same-gender or allow same-gender marriages to occur. Illinois right now is working on a legislative solution. We're hoping the Supreme Court will help us out for California. So next slide. And we see that by generation, there's differing in the level of support for same-gender marriage, but certainly in all adults, no matter, this is a year-by-year analysis, a company who goes every year and asks this question. Meanwhile, it says the silent generation, those born between 28 and 45, my 88-year-old mother now supports marriage equality. So it's a matter of her listening to me. I talked to her, she lives in Texas. I went to visit her, she was in the hospital. Her roommate supports marriage equality. So I think we're finding that people in different generations are really starting to see the light. And it's not just, as they said to us after Prop 8 passed, not just a matter of waiting to let the old folks die off, that in fact we can change the minds of people who are in the older generations. Okay, so it depends on the Supreme Court's ruling, but we're looking at 6 states that can pass marriage equality through their legislatures. And then we need ballot measures to repeal constitutional amendments in 30 states. Okay, next. All right, so this is from an article done by somebody in Marriage Equality USA. I just think this is a cool quote. This was done in March, so this was right when the oral arguments were being done. The first wave of 10 states took 22 years to adopt marriage equality. The second wave of 12 more states should be finished in the next 2 years. What used to average over 2 years per state is now averaging just 2 months per state. Now, since he wrote that article in March, we've had 3 states go for marriage equality through their legislatures and their governors. So if you, and I assume this will all be on your website, if you have questions about sort of what the next states are that we think are going to go, or kind of what the process is, it's also on the Marriage Equality USA website. There's lots of great data there if you're interested. Okay, next state. So how can we all help? All right, you become a straight ally. A straight ally is somebody who is probably, if you're here, you're probably either a straight ally or a member of the community. You're going to support local organizations. Volunteer to help make schools safer for LGBT youth. LGBT youth as a whole are 4 times more likely, since I also volunteer for the Trevor Project, 4 times more likely to attempt suicide than their straight peers. And if they're transgender, 8 times more likely to attempt suicide. So we need to make our schools safe for these kids, all right? You can talk to your local school district about establishing scholarships. Certainly want to support Senator Feinstein's Respect for Marriage Act, which would repeal DOMA incompletion. We also are doing phone banking, and we're doing canvassing in states where it's on the ballot and or in the legislature. So I could really use help setting up some Los Angeles phone banks, especially Nevada right now. They're trying to pass through their legislature. Then it would go onto the ballot because it's a constitutional amendment, but we can always use people to make phone calls, and if you're available during the day, make phone calls to, say, Illinois, to try to get people to call their legislators and legislators and let them know how they feel about the issue. We are a 501c3, so we're a little bit limited on, how much we can do as far as direct canvassing and direct advocacy, but we can certainly educate by phone or in person, and then ask them to let their legislators know. So some quick talking points. The second one I want to really call your attention to. The most powerful quote you can give any person or media, or if you're having a conversation, is your own personal story focused on love, family, and commitment. Talk about exclusion from marriage rather than redefining marriage. Because that's what we've done. We've excluded these couples from what I've been able to enjoy with my husband. Marriage is the center of life. It strengthens the family. Only marriage guarantees that couples can be there for each other when it matters most. I think marriage brings generations together, and it's a fundamental core value of the United States of America. And we are excluding an entire group of people from being able to access that. And we're excluding children, I think, as you pointed out, from the ability to talk about their parents as being married and being the same as others. So, next slide. And then there's some info about Marriage Equality USA. We officially were founded in 2001. We are totally grassroots-based, chapter-based. And we let chapters tell us what's important in their communities and what messaging works in their communities, because as we found in the Prop 8 campaign, one message, one size does not fit all. And we worked really hard. We did an amicus brief around Prop 8 that talked about the stories of couples and tried to bring it down to the human level. And that's what we do when we have media events. We talk to various we did lots of things in City Hall that night. But now news people are interested in talking to real couples, and we do events around real couples, and it's useful if you know a couple to be able to talk about that when you're talking to other people. And then the last slide is just our contact information, and I also have my business cards if anybody's interested. And thank you for having me here.
Several times it said Trevor Project, and I don't really know what Trevor Project is.
Yeah.
The Trevor Project it's very simply put, provides a national hotline for to prevent suicide among LGBT people and youth. It's mostly youth focused, but they've been, I don't know how old the organization is, I think it's less than 10 years old, but very successful, very well respected organization that provides suicide prevention hotlines and advice. Abby Land, who was the mayor, I think she's still city council she's now. Still in the city council of West Hollywood, is the executive director of the Trevor Project. In case you knew that.
And we also go out into classrooms if the teachers ask for it, and we do workshops with the students about suicide prevention. There's also a chat feature and such. So it's to provide resources to help youth who are struggling, and also to help their peers recognize the warning signs of suicide and what do you do if you feel that your friend is ready to attempt suicide.
Let's say made of the argument on DOMA that the federal government almost always recognizes and should recognize any law of a state that isn't unconstitutional, which should, of course, include marriages. And on an international level, isn't it basically common? Again, the United States recognizes actions, particularly marriages, that are illegal in other countries.
What Ken's talking about is actually sort of ironically, I think actually the point that destroys the other side's argument best. Their argument in some ways is, well, the federal government passed DOMA because basically DOMA was this big overreaction to something that was happening in Hawaii. Hawaii became the first state. There was a judicial ruling that suggested it might, under a state constitution, be unconstitutional to bar same-sex couples from marrying. That happened, and Congress completely freaked out and passed DOMA. And the argument they've now made to justify it all these years later is that that was because Congress just wanted uniformity. Congress just wanted to sort of hit the pause button and say, you know, let's just let states sort of work this out, and we're not going to mess with it. We're going to define marriage how we've always understood marriage to be defined, and let the states work it out. But to be honest with you, and because of the point Ken just raised, that's actually a bunch of nonsense, because the federal rule has always been not, and first of all, it was the first time the federal government was really getting involved in defining marriage at all. The rule always has been, for federal purposes, if a law or a program says married people, this is how the federal government, in all cases except for same-sex couples and except for DOMA, determines this. They look to your state and whether your state says you're married. If your state says you're married, the federal government says you're married. DOMA was the complete and almost only exception historically to that rule, period. So the uniformity was the rule we've always had, which is to determine whether you're married, you look to the state. So, you know, I think that's a very good point. And yes, you're right that historically states do recognize marriages from outside the country as well.
I would like to share something that happened in my life. I was on the Department of Public Social Services Commission for the County of Los Angeles, and it was the 1970s. Everybody was against gays, everybody. And we had money to disperse for good causes from the war on poverty. The Board of Supervisors said that we were to decide who gets it. And a group came to us with a very well-written request, and they were marvelous. And they said, we would like to start a gay and lesbian community center in Hollywood. And they had the best written report and the best presentation of any of the groups that came to us for money. And there were 12 of us on the commission. A lady from the Salvation Army and I voted yes, they should get the money. The other 10 people voted no. They should not be allowed to get the money. And AIDS hadn't been discovered yet. And I said something about, what if there was a disease and kids wanted to go with their own kinds to be examined and would feel more comfortable in a gay community center, and they still voted no. So I went home and called up these people who made the presentation, and I said, ignore our commission and go directly to the Board of Supervisors. The Board of Supervisors came to the head of our commission and told him what happened. So at the next meeting, it was Charlie Chan time. He said, somebody in this room has done a terrible thing. They called up these people and they told them that we voted against them and said, go over our heads. And so I said, I did that. I did that. I was proud of myself. And so they said, oh, and then the Salvation Army lady stood up and she said, you are a bunch of bigots. And you know what? They turned around and they voted the seed money for the Gay and Lesbian Community Center. And that's how it got started. So the point of this is nothing's impossible, no matter what the issue. This issue really seemed to be a dead issue in those years. And look at the progress that's been made. Look at what can be done.
The LA Gay and Lesbian Center is the largest, I think, maybe in the world. In the world. And it's fascinating to hear your inside
I didn't know whether I should share it or not.
What's ironic to me is the woman from the Salvation Army that has long discriminated against them. One of the reasons I will never put a nickel in the Salvation Army, bucket is because they don't hire gay people on their staff.
She was an 80-year-old lady, and yes, and she said, you are a bunch of bigots.
Wow.
That's amazing. And I'm going to address something that Lloyd said earlier when he was asking about some of the benefits. I mean, you guys know I'm married to another guy, whatever. So you can wear at the wedding, whatever. So one of the things, we get frustrated over DOMA because of taxes. That's something that's a practical thing, and it's frustrating, and we have to pay extra taxes because of deductibility and healthcare benefits, et cetera. But I'm going to take one thing that you don't think about, and I never thought about it until we went through customs. We went to Canada. You go to Canada, they are Canadian customs. I mean, it's Canada. They're polite. They're wonderful. They're giving you tourist advice. They're asking, where are you going? Oh, you need to go to see this. You need to go see this. Charming people. You can go through together as a family. We were coming back. We were at Toronto Airport, the U.S. Customs pre-clearance, and we went through as a family. And the customs office, an American customs officer said, are you related? Well, we're married. No, you're not. Not as far as we're concerned. And I had to go back to the back of the line because we couldn't go through together. So, I mean, and so it's these things that where you're like, I can't even come back. We can't even come back into our own country as a family because and it has nothing to do with money. It has nothing to do with anything practical. I mean, it was an extra 5 minutes for me to go back and stand in the line, but it was like being in the back of the bus. And we're going to be in Canada again next week. And I always dread coming back and having to go through customs and having to stand in separate lines, and our stuff is together. They want to look at our bags. Well, who put that in your bag? And he did. Well, who's he? So
will DOMA, if DOMA goes down, will that change that?
Better.
We're certainly hopeful. Yeah, no, so I mean, there's a lot of practical, if we win, and I'm hopeful, I'm very superstitious, so I knock on things. Yeah, right, that would be better than this. No, the idea is that what that stems from is that definition problem that DOMA puts out there. You say you're married and they say no, because under their definition of married, you're not. And it sounds ridiculous, but in the eyes of the federal law, it is like you and your husband are complete strangers. And I think you're exactly right to point out we think about the economic harm, but these in legal words, these are things we call dignitary harms that frankly I think cut much deeper. For most people. And thank you for sharing that. But the idea is that for all federal purposes, including at those custom booths, you you will be married, and they will treat you as such, and you will go through as a family as you are.
One last question, because we're almost out of time.
As I understand it, the DOMA case focused on the federal recognition issues and not on the mutual state recognition issues, which really broke the uniformity that you talked about, that the states don't have to recognize each other's marriages. And I'm wondering what, if anything, is happening with the full faith and credit argument.
Not that I'm aware of at the moment. I mean, I think, as with probably all social change, unless you're a real revolutionary, but certainly legal change, it's incremental. So I'm not sort of in the loop on conversations about that aspect of it. It was always a tiny bit more complicated. Frankly, each state, as a matter of public policy, usually has this doctrine where they say the sort of presumption was you accept the court orders of other states, right? And a marriage is like a court order. But sometimes, if another state allows a marriage that's like against your state's public policy, you actually weren't required to recognize it. So it was always a tiny bit more complicated than yes, always have to recognize or not. And it is true, there is a part of DOMA that doesn't get rid of that aspect of DOMA, which says no state is required, basically, to recognize a marriage of a same-sex couple, even when it's valid in another state. But that's where, and as I'll pass it to Jane, that's why there's still a lot of state-by-state work that needs to happen. And my 2 cents about that is, frankly, I think, I'm not saying all that work is a good thing. It'd be nice to wipe it all out in one fell swoop, but I think we're seeing an incredible momentum in the states, and often when it bubbles up in a more local way anyway, that means real lasting change. But that will still have to happen.
Yeah, I think we've seen certainly that the Supreme Court has had some second thoughts about moving so quickly ahead of the public opinion curve on abortion rights. And in the arguments and in the questions that the justices asked about both Prop 8 and DOMA, it was pretty clear they didn't want to be too far ahead of the curve on this one, which is one reason we're working really hard to get these legislative ones done right away where we can, and then support the states that are going to have to go to constitutional amendment. I mean, worst case scenario, they uphold Prop 8 and we have to go back to the ballot. So, if just as an oddity, it's odd to me, it stays in our Constitution even if it's ruled unconstitutional at the federal level. Stuff like that. It's, those weird laws that are in place, like you can't cross the street on a Wednesday or something. It'll be one of those if it's ruled unconstitutional. So we really need, and I would certainly love to have anyone's advice if they have contacts in some of what I call the red states, I think we all call the red states, where we need to start those conversations that nobody thought in this next decade we would be having about marriage equality. The more that we get the news out there at a national level, the more people start to think about it at their local levels. And we need to have chapters starting up talking about their stories in Texas and Kansas and Wisconsin and places where it's going to have to go to a constitutional amendment, but we need to start the conversations now. And eventually, one of these cases will come to the Supreme Court when there is so much public opinion on the right side of history that they'll rule it as a constitutional right. But right now, I can't see that they're going to do that. I totally agree with Melissa. They're going to duck Prop 8. And I would guess they're going to find on federalism grounds on DOMA. So, we just have to wait and see. But meanwhile, we're trying to go forward and work and get these other states moving forward.
Thank you, everybody. I hope you enjoyed and benefited from the session. Thanks to our guests who did such a wonderful job.
And to Steve.